of State of Connecticut Judicial Branch versus Gilbert. Each side will have 30 minutes to argue. The appellant may reserve any portion of that time for rebuttal. Are you ready to go forward?
Yes, Your Honor, and the appellant would like to please reserve 7 minutes for rebuttal.
Okay, Senior Associate Justice McDonald will be our timekeeper. Can you see him?
Yes.
Okay, so he's going to hold signs when there's 5 minutes, 3 minutes, and when your time is up. As to how we're doing the questions and answering, when you see the judge's hand raised or a virtual hand raised, if you please pause your argument, and then I will call on that justice to ask their question. Thank you very much. Whenever you're ready, counsel.
Thank you. Good morning. May it please the court. I am Assistant Attorney General Colleen Valentine, and I'm here on behalf of the judicial branch. There are several significant issues in this case, but the principal question is whether this court meant what it said when it said that Section 46A, 58A provides no basis for claims of discriminatory employment practices that fall within the scope of Section 46A 60. Your Honors, this court has already spoken on this issue in the case of CHRO versus Truelove and McLean, 238 Connecticut 337, 1996. And the analysis applied in that case has not changed since that case was decided. As this court held in Truelove, the only way that the Connecticut General Statutes 46A 58 and 60 make sense together is that each applies to a different type of discriminatory practice. Section 46A 60 applies to discriminatory employment, and 4658A applies to other types of discriminatory practices. I'm sorry.
If I may, Chief Justice.
Yes, I called on you. I'm not sure what's going on with my machine here.
Oh, I'm sorry. I didn't hear you. It was, I'm sure it's my fault. So, counsel, if under your view of the law, if a complainant in Ms. Gilbert's position wants to obtain emotional distress damages for this type of discrimination, how does she do that? Can she do it? And if so, how?
Yes, Your Honor, there's two methods that would enable a complainant as of 2012 to obtain emotional distress damages and attorney's fees for discriminatory employment practices. The first would be to bring a claim at the CHRO and to obtain a release of jurisdiction and bring a case to the Connecticut Superior Court. The second is to, again, bring a claim either to the CHRO or to the EEOC.
Under Title VII, would that be under Title VII?
No, Your Honor. Under Title VII, the complainant would bring a claim to either the CHRO or to the EEOC, and once the claim is dismissed, if it goes to the CHRO, the claim would be first released at the CHRO, and then the complainant would be able to obtain a right to sue from the EEOC, and at that time, the complainant would be able to bring her Title VII claim to either state or federal court.
Would there have been any way to do it under state law, again, back in 2012, any way to obtain emotional distress damages under state law?
And yes, Your Honor, the mechanism to do that would have again been to bring a claim first to the CHRO and then to obtain a release of jurisdiction from the CHRO and then bring a case in Connecticut Superior Court.
Under what authority, though? Under what law?
The Connecticut Fair Employment Practices Act, it would be a 46A 60 claim that would proceed under that statute in the Superior Court. And the Superior Court, as of that time period, was authorized to award emotional distress damages and attorney's fees. It was the Office of Public Hearings, the administrative agency, that had reduced damages available. But the damages were available should the complainant elect to go to court.
What provision in the statute allows for the court to allow to award damages under 46 under 60?
It is, I believe, 46A 104 I believe
46A
is-
104.
I believe so, right. It's 46A 101, 102, 103, and 104, I believe, apply to Superior Court cases. And my memory is that it's 104 that enables courts to award those types of damages.
And does the complainant first must go through the administrative process?
That is correct, Your Honor. In order to go to any court, whether it's state or federal, for a Connecticut Fair Employment Practices Act claim, the case would first have to proceed through the administrative process, and the complainant would need to exhaust their administrative remedies first.
Okay, thank you.
As this court has addressed, the workings of 46A 60 and 46A 58A have different types of discriminatory practices that they address. What the Commission is specifically seeking to do in this case is to have authority to adjudicate. Yes, Your Honor. I will pause.
Thank you. Justice Khan?
Thank you, Chief. I had a couple of questions, which are basically, is the CHRO entitled to deference for its what appears to be ongoing practice of adjudicating Title VII type claims under Section 58?
Your Honor, the answer to that is no. Ordinarily, an administrative agency is entitled to deference when their interpretation is both time-tested and reasonable. Here, there is not, at least none that I was able to find, there is no case that specifically addresses the claim asserted here, which is that 46AA does not authorize the Office of Public Hearings to award damages for discriminatory employment practices cases. So that it is accurate that it has been done following True Love, but there has not been any, as far as I could tell, any specific authority in Superior Court or in the Appellate Court that has tested the CHRO's approach to those claims. And further, it is my position that any argument that True Love authorizes it is not reasonable.
So I have just one additional question, and it's really on another topic. And I know you're probably not there, but I think it's a discreet enough, and I know my colleagues will have questions. I don't want to take up all of the time. And my question is on the issue of the pre-imposed award interest. If the purpose of back pay is to make the employee whole, correct?
Yes, Your Honor.
So why wouldn't an employee be entitled to an award of interest?
Your Honor, the issue is that there is no express waiver of immunity for interests and cost damages against the state of Connecticut. This is not unusual. There are many statutes that will apply differently to a private litigant than it will in cases brought against the state of Connecticut. And so even though interest damages would be awardable in fair employment practices cases brought against private employers, that is not the case when the case is brought against the state, because there is no express waiver of immunity.
Even though the purpose is the same, it's to make the person whole. So if you're a state employee, then you're out of luck, kind of, in terms of being whole.
So I wouldn't say that you're out of luck. I would say that there are cases that there are damages that are not available against the state. And so the mechanism to address that issue is to bring it to the legislature. And if the legislature elects to waive immunity, the legislature, I think, is certainly capable of doing that. And so there isn't, in this statutory scheme, there is not an express waiver for damages for interest And so that is the approach that has been taken with Connecticut Superior Court cases that have all held that without an express waiver, the Fair Employment Practices Act, simply by waiving immunity to suit, has not waived the immunity to interest and cost damages.
Thank you, counsel. I'll yield back to the chief. And
Thank you very much. Justice Keller.
Thank you, Chief Justice. Attorney Valentine, I've been looking at True Love and I've been looking at the Cheshire Board of Ed case. I can't find anything in the Cheshire Board of Ed case that abrogates the holding in True Love. Do you agree with that?
I do agree with that, Your Honor.
I actually found a footnote that says, we do not suggest by our response to the dissent that every asserted violation of every civil right will always yield damages or a broad range of damages. We've held that not to be the case. And they cite the Bridgeport Hospital case, which preceded True Love and went a step further. Correct? And True Love went a step further. Is that right?
Yes, Your Honor. True Love went a step.
Okay.
Yes, it went a step further than the Bridgeport Hospital case. The Bridgeport Hospital case, it did articulate, however, that there was no presumption as of the deciding of that case that 46A58 would apply to any employment discrimination claim. And that case was followed by True Love, in which the court held that employment discrimination claims could only be brought under the specific legislation. And it is certainly the branch's position that Bridgeport Hospital, that the Board of Ed and Cheshire case did not modify or abrogate or overrule True Love in any way.
And in 2019, the legislature actually amended the statute 46A60 to allow for economic damages, correct?
That is accurate, Your Honor. Yes.
So why would they do that if we had already said it was okay, right?
That is the judicial branch's position, Your Honor, yes.
One last question. 2 years before this hearing started, you had an order from a CHRO official that she was not going to be able to present a claim for emotional distress because she had not provided you with documents relating to her claim for emotional distress. So did that order preclude all evidence, including evidence of garden variety emotional distress? Was that your understanding?
That was the branch's understanding, yes. And the distinction between garden variety emotional distress damages and more specific emotional distress damages is primarily that there are cases in which your psychotherapist privilege would not necessarily be waived for a garden variety emotional distress claim. However, there are still non-privileged documents and evidence that would be available, whether it's a garden variety or a more specific emotional distress claim. There are non-privileged documents and discovery that can be conducted. And the problem in this case was that discoverable non-privileged documents that were repeatedly requested and repeatedly ordered to be produced were not produced. And so not having any documents on the full scope of emotional and physical well-being meant that the respondent was significantly prejudiced when the case proceeded to public hearing and evidence of emotional distress was offered, because there couldn't be a full examination and an assessment and testing of the accuracy of the answers that were provided during cross-examination, because you couldn't contradict anything that was being said. And so the only statements that were offered in support of emotional distress damages, it was the complainant statements that couldn't be tested with any contradictory evidence because the complainant elected not to supply the branch with those discoverable documents. And furthermore, the complainant never objected. There was no objection ever lodged to having these documents produced. And so the issue was not even about a privilege at the time that the case was litigated at public hearing. There wasn't a claim that there were privileged documents that were withheld, because if that were the case, then there would have been a privilege log produced. there was no privilege log ever produced here. And so it's impossible to know what specific information was withheld. And so that was why the branch, part of the reason that the branch appealed on that ground, and that was why the Superior Court vacated the emotional distress award on that ground, because fundamentally the judicial branch was not provided with fair process. And so
Why
it was
just subpoena the records? That's what your opponent says.
Why couldn't they subpoena the records? Well, so the records were ordered to be produced in discovery, and they were not produced. And so the judicial branch, before the case actually went to a public hearing, tried multiple times to obtain them. And when they were not produced, the judicial branch moved for an order precluding all such evidence. That order was granted. And so in reliance on the order from December of 2000, I believe it was 2014, from the referee, that all evidence pertaining to emotional distress damages was precluded, there would have been no need to subpoena records because there was already an order precluding those records. And
were you aware of the names of her providers?
There were there were two individuals that were identified before the public hearing. And so there was a request to either provide a release for the records or to actually provide all of the records. And the referee ordered that one of those things had to happen by a specific date. And that did not happen. So there were two individuals.
So there was a second order? There was a second order?
There were, I believe there were 3 orders in October, November, and December of 2014. The first one was an order that occurred during a pre-hearing conference that the complainant, I believe, was to supply all of the records by, I think it was October 31st. Of 2014. They were not provided, and so there was another motion that was filed by the branch in early November of 2014, and the referee at that time ordered that there would be, I think, another 2 weeks that the complainant had to supply the records. They were not supplied in that time period, and then the branch subsequently filed a motion to preclude, which was granted at that time. That was in December of 2014. And so the prejudice here was not simply something that could be satisfied by subpoenaing records. The issue was that the complainant had not complied with discovery, and it couldn't be fixed by just subpoenaing records at trial when the complainant had precluded the respondent from having records during discovery that would inform the strategy of the case.
So the issue is non-compliance and fairness.
Yes, Your Honor, I would agree.
All right, thank you.
Please continue, counsel. Oh, sorry, Justice Ecker.
I don't want to, if any of my colleagues have questions, please let me know, because I've already asked some. But I do have a question on this issue. I guess I just don't understand why this particular question, that is the discovery non-compliance / sanction, is before us. The complainant hasn't appealed, and I understand that there's statutory basis for the commission to appeal, but if she's not complaining, I'm not sure why we should be adjudicating the propriety of the trial court's order in that particular respect. Do you have an answer for me? I mean, it's maybe a question better asked of Mr. Roberts, but I'll throw it your way first. Because, and I'll just add this, it's a complicated issue about, the rights of people to the privacy of their psychiatric records, about what's needed and what's not. Maybe those issues are implicated, maybe not, but I'm just not sure we're in a great position to adjudicate it with the 2 parties that are left.
Your Honor, I do agree that that is a significant problem here, that the complainant has not participated. She did not participate at the administrative appeal level either. And so I don't think that was something that I was strongly advocating that the case should be resolved on simply on the basis that the complainant has not appealed from this issue. I think that the case can more easily be resolved by finding that 46A 58 does not apply to employment discrimination, which would then alleviate the issue. You know, this court doesn't have to, I think, even reach the issue at all. But to the extent that that the issue is reached, I do believe that there is a problem with the commission asserting claims strictly on behalf of the complainant, because the commission does not represent the complainant. The commission represents only the commission, and so I think there is an issue there.
Thank you, counsel. Please proceed. I'm sorry. See, Justice Khan. Thank you.
Thank you, Chief. Counsel, putting aside for a moment just the merits of whether a claim under 60 can be adjudicated under subsection 58, you know, the broader section. The CHRO seems to state that they've been doing it, and there's also a footnote that, you know, they've been doing it for decades. My question to you is, if we were to find that the CHRO cannot adjudicate basically a claim of employment discrimination under 60 under 58 and provide the relief afforded under 58, what is that going to do to sort of what impact would that decision have on the cases that are either currently pending before the CHRO where they've done that or may have been adjudicated in the past? Do you see what I mean? I'm trying to think it. I'm sort of stepping back and thinking of the larger picture, and I'm surprised that if in fact the CHRO is exceeding its mandate, that this hasn't been addressed before. Do you understand first the impact, and then why is it that we're only addressing this now?
Yes, Your Honor. So the first answer, I think, is simply that it wouldn't have any impact on cases that litigants elected not to appeal from. Just as the judicial branch has appealed in this case, I think any respondent who was aggrieved by the decision of the CHRO Office of Public Hearings could have appealed from that decision on this basis. And if they elected not to do that, I don't believe that there would be any requirement that all previous awards be vacated. I think the import is that the damages have been awarded, and if it was in excess of the agency's authority, the time to address that issue was within 45 days of receiving that decision. And so, I think it's a waiver at that point. I don't think there would be a requirement to vacate every award. The other issue of the second issue.
The second issue,
I think it's a double. Why it hasn't been previously. So I can't answer that for anyone other than the state. I can say that for the state, cases resolve in all kinds of ways before it gets to this point. There are cases that awards are issued on other grounds. There are cases in which there are no emotional distress damages awarded. There are cases in which the respondent elects that this is not a case to appeal from because there are other issues.
So just to clarify, is this what you're saying, that in situations where the state is the employer, CHRO hasn't done this, or the case hasn't proceeded to this level where the state felt the need to appeal that issue? But I'm wondering, had the state sent letters to CHRO saying, hey, you're exceeding your mandate, you shouldn't be treating what amounts to Title VII cases under 60 under Section 58? And I know your time is up, and I see my colleague has a question. So once you've answered that, I'm not asking you or following up. Thank you.
What I can say, Your Honor, is that there are many, many cases in which the argument has been consistently asserted in various pleadings. So whether it's a post-hearing brief or a motion to dismiss, it has clearly been raised on multiple occasions with the Office of Public Hearings that this is an excess of their authority to the extent that they were to reach the emotional distress damages issue.
Thank you, Justice Khan. Justice Keller.
Thank you, Chief Justice. One last question, Attorney Valentine. Your opponent argues that the definition of employment discrimination, which is in another part of the statutes, doesn't encompass all kinds of employment discrimination, including this particular type. Would you respond to that? I think that's what he's arguing. It was a little hard to follow, but.
My read was that the CHRO takes the position, and this is consistent with other pending cases before this court and the appellate court, that all authority for any discriminatory claim, employment or otherwise, can be adjudicated under 46A, 58A. And so it is certainly the branch's position here that that is impermissible, and it is not supported by law. And even with respect to the case that was adjudicated in the Cheshire case, there were specific factors in that case that permitted the Office of Public Hearings to adjudicate the discriminatory claim in that case that are, I don't think, present in a lot of other cases, but particularly.
Well, Cheshire was racial discrimination, not employment discrimination, correct?
Yes, Your Honor.
Okay.
Yes, Your Honor. And so it is certainly.
What about sex discrimination? Is that a separate category, or does it come under the employment discrimination if it's sex discrimination occurring at the workplace?
If it is an employment discrimination claim arising out of any of the protected classes, it is the branch's position that it is an employment discrimination claim that arises under 46A 60, and it falls within the purview of that statute. And any employment-based discrimination that falls within the purview of 46A 60 does not fall within the purview of 46A 58A, regardless of the factual predicate, whether it's Title VII, whether it's ADA, whether it's the ADEA. If it's employment, it goes under 46A 60. If it is other types of discriminatory practices that are not employment, that's when 46A 58A comes up, I believe.
All right.
And so in very brief conclusion, oh, I'm sorry.
Just curious, Attorney Valentine, and how that would actually work in practice. What would happen if you had sexual discrimination or racial discrimination in the workplace? You would file your claim with CHRO under both 46, under 60 and 58, but 58 you would just be looking for a release to go to Superior Court? How would that work?
So I don't think 46A 58A is involved at all. I think that if you are filing a complaint with the CHRO with the intention of bringing your case to court, Title VII permits the CHRO to investigate Title VII claims directly. There isn't a need, as far as I'm aware, based on the law, there isn't a need to implicate 46A 58A at all, because Title VII allows the CHRO to investigate claims. What it doesn't allow is it doesn't allow the CHRO or the Office of Public Hearings to adjudicate those claims. And so Title VII claims could be brought for investigation. And then if the complainant wishes to bring the case to court, then they request a release of jurisdiction after the required time period has passed. And then they get a release from the EEOC, the federal branch, and then they can bring their case to court. I don't think 46A 58A has anything to do with it.
Thank you.
All right. Your Honors, I believe that we have covered this. I just want to say in conclusion that this issue, I think, has been fully raised and addressed by this court. The Office of Public Hearings did not have jurisdiction to adjudicate any employment-based discrimination claims under 46A 58A, and so therefore any monetary awards that were granted under that section must be vacated. And the pre and post judgment interest award must also be vacated because there is no express waiver of sovereign immunity to interest awards in 46A 86. And further, the Superior Court's
Counsel,
decision.
you're eating into your rebuttal time.
I apologize, Your Honor. If the court has no further questions, I will rest on my brief at this time.
Thank you. Attorney Roberts.
Good morning, Your Honors. My name is Michael Roberts, and I represent the Commission on Human Rights and Opportunities. I'd like to request 5 minutes of rebuttal on the cross appeal, if I may.
You have it.
Thank you. Your Honors, the judicial branch's appeal should be dismissed and the Commission's cross appeal sustained because plain and unambiguous statutory language authorizes the Commission to act, and it acted in accordance with that language in this case. I'd like to take each of the statutes in turn, beginning with 46A 58, which this court has called our state's fundamental civil rights statute. By its plain terms, 46A 58 renders it a discriminatory practice for any person to subject or cause to be subjected any other person to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or the laws of this state or of the United States. I see a question.
Justice Khan.
Thank you, Chief. And I was trying to get into the queue. I know you're now talking about Section 58, and I assume you were going to tell us what 60 asks. So I apologize that I probably should have waited until you finished that thought before hitting the button, Counsel. But I do have a question, and it relates to this issue. Is there any type of claim that you think can be brought under 60 that cannot be brought under Section 58?
Certainly, there is a significant degree of overlap potentially between claims that could be brought under 58 based on deprivations of other kinds of employment discrimination statutes such as Title VII, but it's not a perfect overlapping circle. Our state statutes, 46A 60, it covers a lot more than our federal statutes usually do. For example, our state employment discrimination statutes covers employers with 3 or more employees, whereas most federal statutes cover employers with 15 or 20 or more employees.
Yeah, but my question isn't who falls under the statute. My question is not so much about who the plaintiff can be, but rather what type of claim, looking only at the 2 state statutes, 58 and 60. Is there any claim that can only be brought under 60 that cannot be brought under 58? Do you see what I mean?
I believe so, Your Honor. So our statute defines discriminatory employment practices. And the specific definition of a discriminatory employment practice is a violation of 46A 60, as well as 46A 81C, which is the sexual orientation equivalent. And so there are going to be claims that fall within 60 for various kinds of employment discrimination that our statute specifically covers, those discriminatory employment practices. And our statute covers conduct that may not be expressly protected by other statutes, state or federal. Our employment discrimination statute has protected classes that may not be covered by federal statutes. And so in that way, there can be claims that are brought specific to 46A 60. And this does, I think, relate to who's covered by 46A 60 as well in terms of employers. There can be claims that are brought.
What type of claims? When you say claims, what type of claims?
Discriminatory employment practices claims, discriminatory employment practice violations. Such as the, the statute covers hiring, firing, a duty to reasonably accommodate. There are pregnancy protections in that statute.
So your position is if someone claimed discrimination on the basis of pregnancy, they couldn't bring a claim under 58. CHRO could not adjudicate that under 58, only subsection 60? Is that your claim?
I think that if someone is pursuing a claim under 60, that they're asserting that an employer that is covered under 60 has engaged in conduct that violates 60, then they can pursue a claim under 46A60. But it may be that there are claims under other related statutes as well.
I understand that. I guess your argument, as I see it, is, look, a claim such as this can be brought under 60, but it's also covered under 58, which is a broader umbrella. And CHRO can do this. And my point is simply, what's the purpose of 60 if any claim under 60 could be brought under 58? And that's my last question. I see both Justice Ecker and Justice Mullins have their hands up. So that's my last question, and I won't follow up, Chief, and I'll yield back after you answer that. So my question is, what's the purpose of 60 if your position is it can be investigated and relief granted under 58?
Well, in the same way that 46A60 covers a variety of actions, and one factual scenario, one employer can potentially have engaged in by one series of events multiple violations of various sections of 60. It can be that one factual scenario violates multiple statutory sections. And so it can be, for example, with respect to Title VII, that an employer can have violated 46A60. But it may be that if they meet the qualifications for an employer under federal law as well, that if they have deprived somebody of their rights under a federal statute based on a protected class that's within 46A58, that they could have also engaged in a violation of 46A58 that's also enforceable and adjudicable. I see there are other questions.
Thank you, Councilman. Next will be Justice Ecker. Justice Mullins, your hand was up and it no longer is. You still have questions?
No, I'll listen to Justice Ecker, but that was my question along those lines. What the point of 60 would be.
Okay, so it'll be Justice Ecker, then Justice Keller. Thank you.
So, counsel, I guess, let's assume that we don't agree with your reading of True Love, the True Love case, which I understand is at the center of your argument. But what's really the harm to a person back then, before the statutory amendment, to Ms. Gilbert or others? I mean, if she had wanted to obtain emotional distress damages, she had the ready means to do so, according to opposing counsel. At least she could have. She would have had to go to court, and she might have had to go through some administrative steps first. But she could have sued under either state or federal law to obtain emotional distress damages. So, really, what's the harm?
Well, our framework exists, our administrative agency exists, and our administrative framework exists so that individuals don't have to go to court. Individuals can come to the agency, and in fact, they must, but they can remain with the agency and pursue their claims there. There's no out-of-pocket expense to file with the CHRO, as there might be a filing fee in court. They can go through the entire CHRO process in a much more expeditious way and in a reduced cost way.
But many employees who claim to have been discriminated against in one way or another, they go through this EEOC or CHRO. And then they get a release from jurisdiction and they go to court. It's not an unusual thing to have happen. You'd agree with that, wouldn't you?
It's not unusual, Your Honor, but that's their option. They can.
And there's no sovereign immunity. Is there? Title VII. The state doesn't have sovereign immunity to a Title VII claim, right?
Correct. That's correct.
All right. You've answered my questions. Thanks.
Justice Keller.
Thank you, Chief. I just wanted to ask you, Attorney Roberts, where you think that the CHRO case abrogated the True Love finding or holding?
Well, there's a footnote in Cheshire Board of Ed where the court certainly calls into question the reasoning on which True Love was based.
What footnote was that? Do you know exactly?
I can find it, Your Honor. But
I couldn't find a cite to the case. I mean, I did a rather quick review of it, but I didn't see any citation of true love. Maybe I missed. I know they cite the Bridgeport case and somewhat favorably. Well, maybe I just didn't go far enough.
in at 270 Con at 723, the court discusses true love in part. And this is on page 9 of our brief, where we discuss this aspect of it, where the court calls into question the basis of True Love's reasoning and the fact that they relied primarily on one canon of statutory construction. True Love, as well as Bridgeport, are pre-1-2Z cases. And so the court in True Love, in part, relied on an axiom of statutory construction, and the court in Cheshire called that into question as to whether that, without more, could be a proper basis for the analysis, especially whereas here 46A58 is pretty clear in its language that that the violation of the statute for any person to deprive any other person of rights under the state law or federal law. And that's one thing that while Cheshire does not expressly overrule True Love in that way, the dissent in Cheshire certainly suggested that there was at least an implicit overruling. Justice Sullivan and Chief Justice Sullivan in that case certainly expressed that concern. And by their questioning of the reasoning in True Love, certainly the court expressed doubt as to its reliance on that in the face of the plain language of the statute.
But it does say in that section you're quoting that section 1015C, which was the Board of Ed's anti-discrimination statute, isn't as narrowly tailored as 46A60. So I'm not sure that they're questioning True Love. I just think they're distinguishing it. But all right, thank you.
Justice Eckert, is your hand still up from before, or you have a question, sir?
I'm sorry. No, I have no question.
Mr. Roberts, please continue.
Thank you, Your Honor. In the same way that this court in Cheshire found that a deprivation of rights under 10-15C could be enforced and adjudicated through 46A58, there's no reason why a deprivation under Title VII should be any different. Our statutes do not distinguish between race and sex in that way. And so the fact that Cheshire was based on a racial discrimination in a school, those were its facts. But at the end of the day, it's the same statute, 46A58, based on a deprivation of rights secured under another statute. There it was 10-15C, and in this instance, it's a deprivation under Title VII.
Thank you, Mr. Roberts. Justice Keller.
But I think the difference is that within the anti-discrimination statutes, we have a separate provision for employment discrimination. We don't have a separate provision like 46A60 for racial discrimination. And therefore, 58 could bring in and trump and be used apart from other state statutes in other chapters to raise the claims. But I think the difference here is that in True Love, we found that if the legislature had a very, as Justice Kahn mentioned, why even have 46A60 if 46A58, you can do the same thing?
Well, it's certainly in True Love, what was being attempted was to enforce through 58 a deprivation of a right secured under 60. But that is not what we have in this instance. It's not that the CHRO was enforcing or adjudicating a 60 claim through 58. There was a 60 claim separately. And here what we have is a Title VII deprivation being brought through 46A58. And there's no, while the court certainly in Cheshire certainly remarked about the specifics of the case that was before it, the plain language of the statute does not distinguish in that way. There's no, and even if the court takes True Love on its face, what True Love was discussing was discriminatory employment practices. And by statute, that phrase is defined to mean violations of 46A60. It does not mean, as the judicial branch has argued, all discrimination claims, employment discrimination claims writ large. It means those specific violations. And so if you take it at its word, true love at its word, that you cannot bring 46A60 deprivations through 58, that says nothing about deprivations under other statutes, state or federal. And this court in Cheshire discussed the breadth of 46A58. It talked about how it's aimed at a wide array of discrimination by a variety of different actors. 46A58 predates our Connecticut Federal Employment Practices Act, 46A60 and 81C. And so the same principles that would apply for a deprivation under any other state law, such as 10-15C, apply for a deprivation under federal law, including Title VII.
Thank you.
Is it all right to go, Chief?
Yes, sir. I think I just did the reverse. I think I muted myself instead of unmuting myself.
Okay.
Yes, please go.
You know, I guess you've been asked this question several different ways, and why not ask you the same thing again one more time? But I'm trying to just understand it. And you just mentioned that 58 existed before 60 came along. Is that right?
Correct.
Just as a matter of trying to figure out what makes sense of these two statutes, 58 and 60, what could be the reason to create 60, and how does 60 exist if 58 can do everything 60 can do?
Well, 46A60 also predates Title VII. And so our state created its own employment discrimination statute. But the lineage of 46A58 is to allow for any deprivations of statutory rights to be still pursued when they're based on a protected class. And so ultimately, by that, the plain language of the statute, that now we now see that can encompass a wide variety of statutes. 10-15C now exists, even though in many respects on certain educational programs, other CHRO statutes cover discrimination in education. And yet, as the court discussed in Cheshire, there may be reasons why you want to pursue claims in different forums and under different statutes. The State Department of Education can allow for a different relief, and it has a different lens through which it views claims than the CHRO does. There may be reasons why you want to pursue a claim under 46A60, in part because that opens the door to back pay, and as we argue here, interest as well. That's what Thames Talent, I'll note briefly, Thames Talent, this court's decision in Thames Talent noted that when the statute uses back pay in 46A86B as a remedy for discriminatory employment practices, it means interest. It's commensurate with interest. Interest is part and parcel of what it means by back pay. Whereas a violation of 46A58 can be remedied through compensatory damages and attorney's fees, among other remedies. So there may be reasons why a complainant wishes to have a 46A60 claim. It opens the door to back pay, reinstatement, but a 46A58 claim will open the door to compensatory damages. And looking at that framework, all of that together, it is reconciled, the plain language and the statutory framework, by permitting 46A58, like deprivations of Title of 10-15C, to be enforced based on deprivations of Title VII as well. The same plain language of the statute would encompass both. And if Title VII deprivations cannot be, then the words in the statute of rights secured or protected by the laws of the United States would be superfluous. If a law of the United States cannot be a basis for a 46A58 claim, that language exists there to allow for deprivations of federal rights to be pursued through 46A58. I want to touch briefly on, yes, I see a question.
Mrs. Keller.
On the injunction, during the hearing, what kind of evidence did the branch put in to show that it would be really prejudicial or inconvenient not to not have the right to assign Ms. Gilbert to other locations as a marshal? Did they talk at all about number of courts that needed to be covered in that particular area, not having enough employees who lived in that part of the state, anything like that?
Your Honor, I don't recall that specific evidence was put in with respect to what an injunction, what effect an injunction might have on the branch.
Did they talk about how it might have an effect on morale or discipline? That if you raised a complaint, even a somewhat unfounded one, at any time you're about to be transferred, you might see a lot more complaints coming up because moving someone to another location could then be alleged as retaliatory.
Well, that's certainly an argument that is made by many respondents.
Was it made during this hearing?
I don't recall that it was made during the hearing itself. I can't recall offhand if it was made in the briefing at the administrative level. I don't want to speak out of turn and say that it was not. But what I'll note with respect to injunctive relief at the commission is that under 46A, 86A, wherever there's a discriminatory practice found, the presiding officer must, the statute uses the word shall, issue an order requiring the respondent to cease and desist from the discriminatory practice, and further requiring that the respondent take such affirmative action as in the judgment of the presiding officer will effectuate the purpose.
And did the hearing officer find that the branch had retaliated against Ms. Gilbert for complaining about this Mr. Marshall Marco?
The way that the decision is worded, it wasn't spelled out so specifically that that it was an act of retaliation. But what the referee did find is that the part of the judicial branch's inadequate response to the complaint of sexual harassment was to transfer Ms. Gilbert away. Since this case, the legislature has codified a requirement for employers that where a complaint of sexual harassment is made, that the terms and conditions of the complaining employee's employment cannot be changed without the employee's express written consent. And so it's not that this was a requirement drawn from the ether. This is now the law in Connecticut by statute, but certainly at this time the referee was required to order injunctive relief, and this relief here was specifically tailored to remedying that improper response of transferring Ms. Gilbert out of the Danielson courthouse.
So you're saying that after someone files a complaint, they cannot be transferred without consent? That's now the law. Okay.
That's now the law. And at this in this case, while that law did not exist to prevent the branch from engaging in the transfer, certainly the referee was empowered to remedy that transfer once it was found that the branch had discriminated.
All right, thank you.
And I would note as well that injunctive order has not been rendered moot by Mr. Marco's voluntary retirement. There were two aspects of the injunctive order: one to prevent Ms. Gilbert and Marco from coming into contact with each other, and one to remedy that improper transfer. Arguably, the order geared towards preventing them from coming in contact with each other has certainly been rendered less effective by the fact that Mr. Marco no longer is employed by the branch, actively employed. But the fact remains that Ms. Gilbert is assigned to the courthouse where she was transferred away, or certainly a courthouse that is farther away from the Danielson courthouse where she was before, and that remains unremedied and is not the injunctive order geared towards that is not rendered moot. I know that my time is running out. I just wanted to briefly touch on the fact that with respect to the documents, I know that there was some discussion about what was ordered before the hearing. I would point the court to, for example, page A133 of the judicial branch's appendix, where what it requests is that in light of the conduct in discovery, the only appropriate remedy is to preclude the complainant from pursuing anything other than garden variety emotional distress. And so there was an opening left for garden variety emotional distress to still be pursued, and that is what occurred here. And garden variety emotional distress, as acknowledged by this court in Patino, can be supported just by the complainant's testimony. It doesn't need medical records. And certainly the federal courts, which have fewer privileges and more stringent discovery requirements, recognize that in pursuit of garden variety emotional distress damages, a complainant or a plaintiff does not open the door wide to all of their medical evidence. And so if the federal courts have that view in cases like In re Sims, then certainly a state administrative tribunal where the strict rules of evidence and discovery don't apply would be better situated to do that. I see that there's a last question.
Mrs. Keller.
Thank you, Chief Justice. One last question. On the emotional damages, is it true that even though she said she wasn't going to allow medical evidence, there was a lot of testimony given by Ms. Gilbert about therapy sessions and medications, and what her doctors said and what her doctors did, and that the referee didn't strike it or exclude it? She just, I mean, did she consider it? Would you say the record's clear she considered that evidence even though she said she wouldn't?
I think that there's certainly evidence in the hearing transcript that some of that evidence came in at various times accidentally. I would say that in most, if not all of those instances, the judicial branch objected. In many of those instances, but not all, the judicial branch moved to strike the testimony that had come in with respect to that. But even if that evidence was allowed,
was it stricken? Was it stricken?
Some of it was. Some of it was stricken. But I don't believe that all of it was. But even if it was, ultimately there was substantial evidence in the record to support the decision, the evidence of other non-medical testimony and the observations of other witnesses, and certainly Ms. Gilbert's demeanor on the stand, which the referee was able to observe. And I see that I know that my time is up, so I don't want to press it. But unless there are any other questions, I'll yield until rebuttal.
Thank you, Counsel. Attorney Valentine.
Thank you very much, Your Honor. The question that was asked several times, and I don't know that it was fully answered, I will answer it. There is no purpose to bring any employment discrimination claims under 46A 58A when you have 46A 60. The purpose of 46A 60 is to address employment claims. It is a specific statute. It contains a number of different provisions. 46A 58A is a one-sentence statute that the CHRO takes the position is sufficient to bring any kind of discrimination claim. And so I don't believe that there would be any logical purpose to bring 46 to even draft 46A 60 if you could do that already under 46A 58A. And so I think that was ultimately, that was the holding in True Love, that you can't have these two statutes unless one means something and the other means something else.
Thank you. I'm going to call in order of the queue. Justice Ecker, then Justice Kahn.
Well, on that point, I had some other questions, but maybe I'll let them go. But on that point, I mean, the purpose would be to vindicate your federal rights, right? I mean, that's what the other side says. The purpose is to vindicate your rights under Title VII. I guess you say that there's no right to vindicate your rights under Title VII in this proceeding. There's just a right to have them investigated.
Yes, Your Honor, it is the branch's position that you may only investigate, the CHRO may only investigate Title VII. But the other issue is that assuming that interpretation is accurate, assuming that Title VII claims can be vindicated under 46A, 58A, none of the protections that are contained in Title VII are being applied. And so you have a 46A, 58A that can only bring in the liability, but not any of the protection available, none of the discovery mechanisms, none of the pretrial practices. And so the idea that you can have this liability, this enormous liability, that you don't get any of the other provisions of that whole statutory scheme applied, I just don't think that there's any other law in this state that does that. I don't think that one sentence in 46A, 58A imports the significant liability found in Title VII, but doesn't give any of the respondents the protections that are available under that same statutory scheme.
I have a quick question on the injunction, wiping out the injunction. You know, I understand the concern about the fact that it appeared to be time unlimited, but it's a little odd to me that the hearing officer would have no ability, you know, if one sees the transfer of the complainant as kind of like backwards, right? I mean, here's a valid complaint of sexual harassment, and instead of transferring the bad guy, in quotes, you know, you transfer the victim, and that's offensive and should be remedied somehow. So if an injunction is an appropriate way to remedy, I mean, what would have been an appropriate way to remedy that act of discrimination?
So the answer, I think, first is that the branch is not taking the position here that the Office of Public Hearings has no authority to issue an injunction. That isn't the argument. The problem here, there's a few problems, the most significant of which is that Ms. Gilbert was actually already assigned to the Danielson courthouse at the time of her testimony in 2017. And so between her testimony in 2017 and the decision that was issued, there was no change in circumstances in the evidence. And so she actually was already assigned to that courthouse. And so what this injunction did is it didn't remedy past discrimination. It gave her the ability to prevent the judicial branch from ever transferring her again. That's one of the problems with this injunction, that factually, that there wasn't any basis for it. The other issue with it is that to the extent the claim is that it was retaliatory, there's no claim of retaliation in this case. In fact, the complainant sought to amend her complaint to assert a new claim of retaliation, and the hearing referee denied that. And so,
well, maybe it wasn't retaliatory; it was just discriminatory. You know, it just the employer just picked the wrong side to fix the problem. I mean, isn't that possible as a way of conceptualizing what occurred?
I would say in this case that's not accurate. I would say conceptually it's certainly conceivable that could happen. That isn't what happened in this case. The transfers, it's actually a rotation, and it's done twice a year. And the first opportunity to transfer or to rotate Ms. Gilbert was in February of 2012, and that was after her complaint. She didn't get transferred at that time. She was only rotated the following August, 6 months later. And at that point, both she and Marco were rotated over the course of the next several years into different courthouses. And Ms. Gilbert was subsequently transferred and rotated back to Danielson. And so she was, in this case.
Thank you. I yield to, there's other people with questions.
Justice Khan?
Thank you. Thank you, Chief. I just have a point of clarification. Earlier, in response to, I believe, Justice Keller and Justice Mullins' questions, perhaps even Justice Ecker, you said, look, the CHRO can investigate Title VII claim. And then the Ms. Gilbert could have requested leave either a finding that she had a case that could be brought to court, or if they didn't make a finding, a release that she could file in court. Let me ask you just practically, is the CHRO, would she then still have to file with the EEOC for exhaustion? Or is CHRO sufficient for purposes of her to get permission to go to court to file her claim?
Your Honor, the answer is that whenever a complaint is filed with the CHRO, it is deemed duly filed with the EEOC if there are any federal claims raised in the complaint. And so if there is a Title VII claim raised in a CHRO complaint, it will automatically generate an EEOC number. And if the complainant wishes to receive a right to sue from the EEOC, all they have to do is wait the requisite period and then contact the EEOC and say, okay, I want this case out of the EEOC and I want to bring it to court, and that's all they have to do.
And so your position is that the CHRO can investigate claims under 60, under 58, and also under Title VII, but they can only issue relief under 60 or 58. But if it's employment discrimination, it falls only under 60, and anything above and beyond would have to be, for Title VII type violation relief, would have to go to court.
That is exactly correct, Your Honor. Yes.
Thank you.
I know that my time is up at this point, and so I won't go through any of the other discussions that I had. If there are no further questions, I believe that this court has a strong grasp on the issues and facts in this case, and at this point, I will rest on my brief.
Thank you very much, counsel. Attorney Roberts.
Thank you, Your Honor. The Commission's statutory framework is clear, and it's based on plain and unambiguous statutes. There are express exceptions where the legislature has chosen to make them, and where the legislature has not, those exceptions do not exist. The judicial branch has sought to create exceptions that aren't there. For example, with respect to the injunctive relief, there is no time limitation in the language of 46A, 86A. The referee is empowered and in most cases must at the very least issue a cease and desist order and affirmative injunctive relief. I see a question.
Mr. Zucker.
On the, I understand why the statutory question is in front of us and why, your client has a distinct interest in its adjudication. Why are we looking at this essentially discovery sanction? What standing does your client have to ask us to adjudicate that determined portion of the judgment?
Well, as Your Honor noted, this commission has an interest in its decision-making and its decision-making ability. What's being challenged is the decision in this case to award emotional distress damages for the violation of 46A 58. Certainly one aspect of that is the authority to do so, which is plainly set out in 46A 86C. But the other piece of it is whether the commission properly did so here. And what the Superior Court determined was that the commission erred in the way that it did that and vacated the award completely. And so the commission has an interest in preserving the validity of its properly reached decision here, which was to award garden variety emotional distress damages based on the record in the case.
Well, when a trial court gets reversed by an intermediate appellate court, it doesn't. It cares that maybe the judge, says, hey, that's not right. I was correct, but it doesn't. The court doesn't have standing to appeal it. So I'm just wondering. This seems more like the kind of thing where the appropriate party to appeal would be the party who's having the money taken away from her.
Well, I think a court is a little bit different than an administrative agency when it comes to appeals. Certainly, the Commission has a long history of appeals that it can bring itself, and it has a history of appeals in which it's defending itself, which is different than a court. When a decision of a court is appealed, no one is envisioned to be the person who is defending that decision. But for an administrative agency, from the history of our administrative process, there has been a party, the agency itself, that is in the role of defending its decisions. And so here, where the Commission is aggrieved, just as in Williams versus CHRO and other decisions, the agency has standing to pursue its own appeals where its decision-making ability is implicated, and that is what has occurred here. And so with respect to the relief, the Commission is empowered to argue that substantial evidence in the record supported that decision, and with respect to the injunction as well, that the referee was empowered and properly did so. Ultimately, even if the court finds specific errors in some of those aspects, whether it's the nuances of the injunctive relief, whether it's the specifics of the award for emotional distress, the correct response is to award a remand and permit the agency to correct those errors, permit the Commission and in its prosecutorial capacity and the complainant for her own part to present evidence to cure it as occurred in Ann Howard's apricots, not to simply vacate those remedies entirely and leave the parties without any opportunity to fix that error. And so while the Commission is comfortable in its argument that there was no error with respect to the injunctive relief and the specifics of the emotional distress award here, if the court finds that there was error, then there should be a remand rather than a complete vacating. And I know that I'm reaching the end of my time, but so unless there's any other questions, then I will rest on that.
Saying none, counsel, thank you very much. I thank both counsel. I really appreciate it. We are in recess until January 20th. Thank you very much. I will see my fellow justices in the virtual conference room.